Well, welcome back, everyone. I hope you had a nice weekend. Uh, Great day on Saturday, terrible weather on Sunday, and a terrible Browns loss. Oh my gosh. So we're into week 11 already, which is amazing. We're more than two-thirds of the way through the semester. I appreciate you accommodating that I'm not in class tonight. I'm working the polls tomorrow, and I have a last-minute training this evening, so I'm presenting this by YouTube video. And I hope everyone can hear my narration okay. And you hope you all received the link telling you where to find this in the first place. Just a reminder of what we are talking about and have been talking about when we talk about fiduciary duties. Remember, it's the separation of ownership from control that's the premise for fiduciary duties. Three aspects, or three prongs, or three legs, or whatever metaphor you want to use: the duty of loyalty, duty of care, and then there is a third leg of this, which all courts don't necessarily recognize as a third leg of it, but I do, and a lot of the statutes at least discuss this as an overarching concept, which is a duty of good faith, and to be acting in good faith in everything that the party with the fiduciary duty is doing on behalf of the person to whom the duty is owed. Last class, when we were talking about fiduciary duties of LLC members and managers, we talked at the end of the class about the Uriga Capital Corp versus Getz Properties case. And the takeaways from that is that courts will apply principles of equity when interpreting an operating agreement, especially where the operating agreement does not expressly eliminate common law duties of loyalty and care. So where does this come from? Well, in some cases, from actual statutory language, and other cases from common law that's developed by the decided cases. As we've seen, some of the courts kind of combine together common law concepts of duty or fiduciary duty with what might be in the statute, which, as we know, is sometimes incomplete, sometimes imperfectly drafted. While most LLC statutes give parties a lot of leeway in creating their own rules of engagement, that leeway is not unlimited. Most statutes provide that the operating agreement cannot eliminate the implied covenant of good faith and fair dealing, and in some cases cannot eliminate fiduciary duty outright. And we're going to talk about that in a little more detail further on in this lecture. If you look at note 3 on page 371, our author posits the question, to whom are fiduciary duties owed in a manager-managed LLC, suggesting that some LLC statutes limit a manager's duty to the LLC itself and not the individual members. And there's a distinction there that we're going to talk about a little bit. Remember that under RULLCA section 104, a limited liability company is an entity distinct from its members. That being the case, to whom does the LLC manager owe a duty? If we think of an LLC manager as the functional equivalent of the board of directors of a corporation, with the members as the functional equivalent of shareholders, it suggests that a manager's primary duty is in fact to the LLC, just as in a corporation, a corporate director's fiduciary duties are generally owed to the corporation, which is, of course, also an entity separate from its owners. The text talks about the case of Allentown Ambassadors, Inc., a 2007 federal district court case from the Eastern District of Pennsylvania that addressed this issue. The plaintiff in Allentown was an owner of a minor league baseball team that was a member of an LLC, which was in fact a baseball league that failed. The plaintiff went into bankruptcy. In the bankruptcy court proceedings, there is the possibility to have what's called an adversary proceeding, which is litigation within the bankruptcy case itself, sometimes against people who have perhaps caused the bankruptcy or who owe money to the bankruptcy estate. In this case, the plaintiff sued the league commissioner, who is also, by the way, the manager of the LLC and a member of the LLC. He owned one of the teams that was part of the league. His name was Miles Wolfe. And the plaintiff alleged that Wolfe's breach of fiduciary duty was one of the main causes for the failure of the league, which led to the bankruptcy. Apparently, some of the teams in the league had been permitted to, quote, go dark, quote. That means they're basically allowed to suspend operations for a season in order to stem losses and perhaps regroup. But the commissioner had not permitted the plaintiff to do the same. And he also had not assisted the plaintiff in finding a buyer for the team as he had done for other teams in the league. This was a really small minor league. Finally, he'd refused the plaintiff's request for financial assistance, even though he had approved similar requests from other team owners in the past. Now, defendant Wolfe defended this by analogizing to the corporation model that we just discussed, basically saying that his fiduciary duty was only to the league, not to the individual members like the plaintiff. Also, there was a North Carolina statute at issue which apparently did not explicitly state that an LLC manager had fiduciary duties to individual members. This is a case of one of those statutes with some gaps in it, perhaps. The court wasn't necessarily convinced by Wolfe's argument and analogized to another corporate application of fiduciary duty, which states that majority shareholders have a fiduciary duty to minority shareholders. And this is because, consistent with our diagram earlier on, majority shareholders typically are in a position to control the financial interests of minority owners in the entity. And this concept of the fiduciary duty of majority shareholders to minority shareholders is well established in almost all states at this point. The judge writes, quote, "While my research has uncovered no controlling precedent, I predict that the North Carolina appellate courts would extend to LLCs the principles developed in the law of closely held corporations that are designed to protect minority shareholders," end quote. Quick tangent. When we talk about closely held corporations, or as the judge talks about closely held corporations, he's talking about corporations whose shares are not traded on a public market. When shares are traded on a public market or on a stock exchange, it's easy for minority shareholders to liquidate their investment and avoid the whole problem. With closely held or private corporations, fiduciary duties take on a higher level of importance because of the relatively illiquid position of the minority shareholders, that is, the absence of a ready market for their securities. So after that tangent, I guess I want to talk a little bit about part of the case that's not excerpted by our authors, and it suggests some possible other reasoning for the way the court came out on this. I'm going to read another part of the opinion that's not in our textbook. Quote, "While I can envision a number of perfectly reasonable explanations that would justify defendant Wolfe's business judgment in failing to assist the debtor in the manner alleged in the complaint, I am once again unprepared to rule on the issue given the present state of the record. The debtor may have a difficult time providing that defendant Wolfe breached his duty, but in making all reasonable inferences in favor of the debtor and consistent with the theory underlying the debtor's claim under the Bankruptcy Code, both defendant Wolfe, in his capacity as a member, and the other team members possibly stood to profit from the conduct which would cause the debtor to forfeit its membership in the league. Thus, I perceive at least the possibility that the challenged conduct, by that he means the conduct on the part of Wolfe, was part of a pattern designed to oppress the debtor and devalue its membership interest, period. I include that the debtor is entitled to obtain discovery and pursue this theory. This was a motion to dismiss. So the judge is looking at some of other factors that may have constituted a breach by this particular manager to this particular member, and in the way we've seen with some other cases involving oppression of minority owners of these closely held entities. I guess in summing it up, my observation is Allentown is an example of how the common law changes. Sometimes it's just a particular jurist speculating or analogizing or guessing or bringing in other factors that may not directly be on point to come up with an equitable solution. So let's take another look at RULLCA section 409 from last night. I'm sorry, from last night to last week, to see if there's any guidance on this question that we were talking about in the last case. So standards of conduct for members and managers of LLCs. First, a member of a member-managed limited liability company owes to the company and, subject to Section 901B, the other members, the fiduciary duties of loyalty and care stated in subsections B, which is the loyalty prong, and C, duty of care prong. Goes on to say that the member in a member-managed LLC or a manager-managed LLC shall discharge duties basically in good faith and with principles of fair dealing. That third prong of the fiduciary duties we've been talking about. We haven't looked at RULLCA section 901B before, and this is apropos of this issue of to whom the duty is owed. This section says that a member maintaining a direct action must plead and prove actual or threatened injury, not simply by virtue of the fact that they're a member, but it's something specific to them, that they suffered the injury uniquely in their own name. Now, this appears to establish the fact that in a manager-managed LLC or a member-managed LLC, the manager has a fiduciary duty to the LLC itself, as well as to the individual members, as long as the harm suffered by the member stems from harm that the member suffered independently from harm that the LLC itself may have suffered. Why do we have this proviso? Why is this in here? Well, again, this appears to borrow from the LLC's corporate legacy. And for those of you who haven't had corporations, I apologize. I'll try to make this clear. When a shareholder is harmed as a result of harm to the corporation, the shareholder's remedy is to ask the corporation to take action against whomever caused the harm to the corporation. Now, this is because, as we know, the corporation is a legal entity, is a legal person that can suffer harm. And if I'm a shareholder, I will suffer harm indirectly because of something that's happened to the corporation. And in those instances, if the corporation doesn't step in and defend itself and take action, I'm allowed to step in and ask the corporation to initiate legal action against that third party to provide a remedy for the corporation and indirectly for all of us shareholders. This is something called a shareholder derivative action. In other words, the rights are derived from the corporation's rights as the primary entity to whom harm was done. So by distinction, we have something else in corporate law called a direct action. And that's where the harm has happened to the shareholder directly, not necessarily to all the other shareholders in the same way, but something that uniquely has hurt this particular shareholder. So derivative actions are actions taken in the name of the corporation on behalf of all the shareholders. Direct actions are actions taken by individual shareholders because they've suffered unique harm. And if you may remember from civil procedure, Civil Rule 23.1 dealt with this concept of these sorts of derivative actions in the context typically of something that is teed up as a class action. The more interesting question is, what's the manager's fiduciary duty in those instances where the interests of the LLC and one of its members are at odds? Suppose I am an LLC manager who has had a contract with the member's company to purchase widgets, and I find a better, cheaper source of widgets. Can the member accuse me of breaching my fiduciary duty to the member, or is this simply a matter of contract law? So summing up, at least under the RULLCA, the manager's fiduciary duty is primarily to the LLC itself, unless the member can establish that there was a direct harm suffered that was unique to that member, not suffered by everybody else because it was a wrong against the LLC. In that instance, there may be a duty owing to specific members uh, in addition to the LLC. So let's change gears a bit and take a look at the section of the text, uh, subsection B, members and managers fiduciary duties. I want to look specifically at the Pappas versus Solis case, the New York case from 2012. So what's going on here? This is another New York real estate venture gone bad, a la the Meinhard versus Salmon case we looked at earlier, in which Solis, Pappas, and another member, we don't know who that is, we'll just call him John Doe, form an LLC to lease and manage an office building. The new LLC was actually the lessee. Uh, each member contributed 50,000, and Solis committed to post and maintain, meaning if the security deposit gets drawn on, he will re-up it to reach the level of $1,192,500 security deposit. Solis was permitted under the operating agreement to lease the building. He was given that power, and he subleased it to one of his companies. And by the way, members of the LLC were permitted under the operating agreement to, quote, engage in business ventures and investments of any nature whatsoever, whether or not in competition with the LLC, without obligation of any kind to the LLC or to the other members, end quote. That looks a lot like the sort of carte blanche clause we've looked at in other cases in the last week or two, and as we know, there can be problematic. So, as often happens, there were disagreements within the LLC, and in January of 2007, Solis proceeded to buy out the other members for $1 million each. The members represent that they have done their own due diligence, had their own counsel, went into this buyout transaction with eyes wide open, fully informed. In August of 2007, Solis assigns the lease to Extel Development for $17,500,000. By that I mean the original lease that they got in this venture. So the bought out members sue for breach of fiduciary duties. They sued Solis on the theory that Solis knew about this Extel deal when Solis was negotiating to buy out the members. In other words, he got the other members to sell out cheaply, knowing that a much bigger payday was just on the horizon. So what is Solis's defense to this? Well, the operating agreement clearly waived fiduciary duties in stating that any of the members of the LLC could, as we said, engage in business ventures and investments, whether or not in competition with the LLC. Well, procedurally, the trial court threw out the complaint, and the appeals court reversed on the fiduciary claim, citing what else? Meinhard versus Salmon. This court threw out the remaining fiduciary duty claim. So what was the rationale here for this court? Well, the appropriate test of whether Solis had a fiduciary duty to his fellow members comes down to this: whether, given the nature of the parties' relationship at the time of the other members' buyout, was Solis aware of information that would make the plaintiff's reliance on Solis as a fiduciary unreasonable. So what do we look at to come to that conclusion? Well, here the parties were sophisticated. They had investing experience and a certain amount of savvy. Other thing to think about is that the parties were already in a confrontational position when the buyout started to happen, such that they should know that they shouldn't be relying solely on Solus for anything. They each received $1 million for their $50,000 investment. So what's the problem here? Put another way, in the absence of a statute or an operating agreement provision, why would Solus have a fiduciary duty in the first place? Does the separation from control principle apply, since Solus was given the right under the operating agreement to sublet the leased building? Stated more generally, if members all have proportionate rights and responsibilities in an LLC, why should any LLC member have a fiduciary duty to the other LLC members? If I have the same vote as any other member, do I lack control? Remember, RULLCA Section 409A imposes fiduciary duties based entirely on the relationship between the parties. If the LLC is member managed, you as a member manager have a fiduciary duty to the other member managers. The question, can this apparently mechanical imposition of fiduciary duties be varied by contract, by creating more specific or more limited duties in the operating agreement? And the answer is yes. And parties commonly address this otherwise open-ended fiduciary duty in the statute by creating specific rules aimed at addressing the most likely liability scenarios. I guess this is as good a place as any to discuss what parties can and can't include in their operating agreement. The presumption in the LLC world, much like the partnership world, is that parties should be free to create their own rules of engagement. Like partnerships, LLCs are largely governed by contract, that is, the operating agreement. And that is why the statutes typically have lead-in language that says, except as provided in the operating agreement, for instance. That being said, are there any limitations on what can be included, or more importantly, enforced in an operating agreement? Here's RULLCA Section 110 Operating Agreement, Scope, Function, and Limitations. I'm just excerpting this for you. I want you to be familiar with the whole statute. The general concept is it talks about what you can put in an operating agreement. Subsection C starts to talk about what you may not do. And I'm highlighting these sections that are apropos of what we're talking about today. An operating agreement may not, subject to these other subsections, eliminate the duty of loyalty, the duty of care, or any other fiduciary duty. So what are those other sections about? So if you look at subsection D, it says, if not manifestly unreasonable, an operating agreement may restrict or eliminate the duty to account. We looked at that before, accounting for profits. You could restrict, if it's not unreasonable, the restriction on dealing with the company on behalf of someone having an interest adverse to the company. And again, if not manifestly unreasonable, you can restrict or waive the provision that would otherwise obligate a member to refrain from competing with the company. So again, the lead-in language is if not manifestly unreasonable, we can modify these duties however we decide to do it, and I guess that's the stuff of lawsuits. Subsection G, which I'm also highlighting there, is the operating agreement may alter or eliminate the indemnification for a member or manager provided by Section 408A, and may eliminate or limit a member or manager's duty to the limited liability company and members for money damages, except for breach of fiduciary duty. What are we talking about here? So we've talked about the concept of indemnification before. Those instances in which an entity will make one of its constituents whole if they suffer harm in certain instances, and that's an incentive for people to become investors in these entities or to serve on boards of directors, etc. Um, but what this specifically says in the case of an operating agreement and what you can and cannot do, you can modify, you can even eliminate indemnification for certain things that a manager or a member might do, but you can't eliminate, you can't completely eliminate uh, indemnification if the harm resulted from a breach of the duty of loyalty. My point is that uh, the court, I think when the drafters of this particular statute recognize the fact that, and we've seen it in some of the cases, that there in certain judicial and academic circles, there's opposition to the idea of blanket fiduciary duty for LLC actors. What this statute allows is for companies to modify a waiver of fiduciary duties, but only if it's reasonable. And that, again, what does that mean? We don't know. That's contextual for sure. Section 110, I would submit, reflects a recognition of the complexity that can exist in real world, closely held, unincorporated entities. The blanket imposition of fiduciary duties based solely on a generic relationship that is purely status based is arguably overbroad and has the potential to create landmines for even the most carefully formed entities. And therefore, as I said, Section 110 allows parties to carefully modify what would otherwise be fiduciary duties imposed by perhaps by common law or maybe by other sections of the statutes. I've only excerpted certain subsections of RULCA section 110, but I expect you folks to all have read that entire section because that material will come up on the exam when it comes to how we possibly carefully modify fiduciary duties in these types of entities. Section 7.1 of the model agreement, at the back of your text on page 598, addresses some of these concepts of waiver and what would otherwise be a breach of fiduciary duty. So looking at section 7.1 of the model agreement, 7.1 addresses manager's standard of care. And again, this was just something that was drafted by a private party. It doesn't necessarily cite any statute. Manager's duty of care in the discharge of manager's duties is limited to acting in good faith and refraining from engaging in grossly negligent, reckless, or willful misconduct. Pretty straightforward. Doesn't talk about being informed necessarily, but there it is. Section 7.2 deals with self-dealing in outside transactions. Remember, this starts to look at the duty of loyalty prong of fiduciary duty. A manager has a duty not to engage in a transaction with the company if the manager has a direct or indirect interest in the transaction, unless the transaction is fair to the company or the members owning a majority of the sharing ratios, knowing the material facts of the transaction, approve it. Again, there's this kind of ambiguous reference to the word fair, and as we know from some of the cases we've looked at, that is sometimes construed by courts, sometimes construed based on the relative sophistication or knowledge of the parties, sometimes construed by looking at the overall finances of the entity, but it also incorporates this concept of disclosure and transparency, which is really, really important when it comes, especially comes to conflict of interest transactions, self-dealing transactions. If it is fully disclosed and approved by, in this case, a majority of the sharing ratios, meaning the percentage interests in the entity, knowing all the facts, it'll be sanitized. The next one I want to skip to is section 7.4, which basically says that um, otherwise, except as what we've stated in this section of the operating agreement, no member or manager has any duties, including fiduciary duties. So it's just a blanket waiver of fiduciary duties, except as they've attempted to uh, restate them or describe them in this operating agreement. I guess a question that might come up, if perhaps in court, perhaps on an exam, is would one of these or all of these provisions hold up if compared to the provisions of the ULLCA or perhaps the RULLCA? Remember, we said before that just because you've drafted something a certain way doesn't mean that it's necessarily going to be enforceable in court. Here's another example from, let's say it's an LLC that owns let's say it's a Ford dealership. And here they've attempted to further define fiduciary duty the way we've seen that some of the statutes contemplate that parties will specifically state the sort of things that will or will not constitute a breach of fiduciary duty. So in this one, no member shall be deemed to have violated its fiduciary duty of loyalty to the company or its members by owning or operating a dealership that does not sell Ford vehicles, or owning or operating a car dealership, should say car dealership, of any kind that is located, should say outside of 10 miles of the company's existing business premises. So they've made an effort to more specifically define what is and what is not fiduciary duty. Owning something that's not a Ford dealership, owning something that's more than 10 miles away from an existing company business location. Would these hold up under the RULLCA and under the ULLCA that we've looked at? I don't know. That's something that we might analyze, as I said, in court or on an exam. Here's yet another attempt by an LLC to customize the fiduciary duty obligations of its members or managers. This was for a law firm. No member shall be deemed to have violated its fiduciary duty of care to the company or its members unless there's a final decision of a tribunal finding the member has committed professional malpractice, and any such final decision awards a monetary judgment that is not covered by the company's malpractice insurance. So here, they've tied it very specifically to the types of risks that are inherent in this particular enterprise. In a law firm, the biggest risk is a malpractice lawsuit against the members or against the LLC itself. So here they've tried to make it clear that there can't be a violation of the fiduciary duty of care unless there's a judicial decision involving money that's not covered by insurance. So a pretty good attempt to fine-tune the contours of the duty of care prong of fiduciary duty in the law firm context. Another example for the law firm model. No member shall be deemed to have violated its fiduciary duty of care, again, duty of care, to the company or its members if the subject act or conduct is approved or ratified by at least one other member who has not been subject to a duty of care violation within the prior 5 years. Maybe the way this works is that the action that's being challenged was run up the flagpole within the firm, and you ran it past the ethics guru in the law firm, who typically is the person who advises the other members of the firm on ethics issues. And assuming that person hasn't been subject to a duty of care violation within 5 years, that sanitizes it for purposes of liability, again, under the particular operating agreement. That's what we're talking about here. All these contractual attempts to customize fiduciary duty speak to liability within the LLC among the members and the managers. It, of course, doesn't necessarily deal with liability to third parties outside of the operating agreement. But again, this is an example of parties trying to fine-tune and customize fiduciary duties the way that the RULLCA contemplates that parties might be able to do that. You can imagine there are so many different ways that these can be modified that that's why these things find their way into court. We make our best efforts to try to define these things in contract. They don't always hold up. There are sometimes gaps in what we contemplated when we drafted them. So this whole idea of minimizing fiduciary duties by limiting risk via these other provisions of an operating agreement, assuming the existence of fiduciary duties among members due to some kind of control that one member has over another member, is it possible to minimize through the operating agreement those circumstances that might lead to a claim for breach of fiduciary duty, a kind of risk management approach? So for example, if the most likely way for one member to take advantage of the other members is through theft of funds, wouldn't it make sense to build protections into the operating agreement that strictly control a member's access to cash or whatever else a member could steal from the limited liability company? For instance, a provision that requires X number of members to okay any disbursement of funds. These are more like behavioral controls that are put in place aside from defining what is a breach of fiduciary duty. These are provisions that would control behavior so that it wouldn't even get to the point where someone's being challenged for a breach of fiduciary duty, because if they violated one of these other provisions of the operating agreement contract, they've breached a contract, a breach of contract claim, not necessarily a breach of fiduciary duty claim, if you follow what I'm saying. The problem of how to waive or contract around fiduciary duties is the starting point for section 8.04, private ordering of fiduciary obligations. We've gotten a flavor for it in the last 5 minutes as we've talked about some of these efforts to contract around some of the default rules for fiduciary duties. All right, let's talk about Wednesday. On Wednesday, as the syllabus says, we're going to have our second in-class hypothetical on materials that we've already covered this semester. I say, quote, in class, quote, although you will obviously be completing it wherever you are. Time limit for completion is going to be the scheduled class time, unless you have an accommodation from the administration. As before, I will email everyone the exercise with instructions, including how to return it to me. And remember to send it not to my CSU email address. Several of you did the last time. I don't use that address. So if you please send it to the Russo Law email address that I will have in the instructions, that'll speed up my review. I mentioned before that these hypotheticals are intended to give you a bit of a preview of the format for the final. And because the first one that we had was somewhat of a essay type of response or a longer type of response, the one on Wednesday is going to be either very short answers or slightly longer answers. In either case, with a word limit, that'll be a little more succinct and will be based on probably a number of fact patterns or maybe just one fact pattern. But it'll be, again, more precise and discrete in terms of questions that are asked, a little more black and white, if you will, in terms of how you can respond to them. After we do the hypo, we're going to, as I said, we're going to get back onto this issue of private ordering of fiduciary duties. And that will be the end of our conversation about fiduciary duties for the semester. That will be next Monday. If anybody has any questions, any comments, as always, feel free to email me or text me. Again, thanks for hanging in there as I presented this lecture via YouTube. Not my first choice, but it's one time situation. Hope everyone has a great rest of the evening. Good night.